So the first of it is a company called Spectrol Inc. And what happened with Spectrol Inc. is there's a very much like the time frame to file the SR&ED claims, there's also specific time frames to file objections or appeals. And as many of you know, usually you get a notice of assessment you don't agree with. You have 90 days to file on time your objection in T400 form. What happened in this company's case is there's actually another caveat under the Act that says if you miss that and you have a good reason, the Act will allow you to extend that for up to a year. You can get an extension of 1 year for this. And in a nutshell, the client didn't file an objection where you basically disagree with the Canada Revenue Agency and you file an objection with the Canada Revenue Agency. They went to the next level. They made a mistake and filed an appeal to the Tax Court of Canada, which is generally the next level. And the proper process is you disagree with the CRA, you file an objection with the CRA. You either wait for the CRA to say, hey, it went back to the guy who disagreed with you in the first place, so he's not going to change his mind, and he's going to say, hey, we're not changing our mind. That takes a year or two. But what you have to do is you have to file the objection, and you can wait 90 days. You know the CRA is generally not going to change its mind on an objection, or I've found that, because it's always going back to the same people who didn't agree with you in the first place, and you already had your chance to convince them. When I'm filing an objection, I'm not hoping any response from the CRA. I'm waiting my 90 days, then I'm filing to the Tax Court of Canada, because at that point, now I know I get to deal with a litigator. I get to deal with someone at the Crown, who's a lawyer, who's going to talk Income Tax Act. And then once we can talk the Income Tax Act, I don't care about ITs or ICs or whatever they say. We'll follow law. Hopefully I can convince them we've got a good legal argument here, and we're going to settle. It's going to be done very quickly. This client made a mistake. I guess they had bad advisors, or they tried it themselves. They didn't realize that before you file to the Tax Court of Canada, you have to file the objection first. What happened here is they missed the filing for the objection, but they said, well, we filed this appeal to the Tax Court of Canada, and we think we sent a copy to the CRA. Couldn't prove it. And the judge said, well, you guys didn't know what you were doing, but you filed all the facts and the issues that you would have filed with the CRA with the Department of Justice instead, so you sent it to the wrong agency, but you still filed the stuff on time, so we're going to let it go. Right? So I'm saying, well, usually you want to file the right forms with the right agencies, but it just shows me that the tax courts are really willing to be lenient with a guy who didn't file the right forms on time, arguably filed the right information, albeit with the wrong agency, and the courts were willing to give them the benefit of the doubt in this case, and said that since they filed with the tax court, it was probably likely they filed with the CRA as well, and the CRA just lost it because it wasn't addressed to them. Deemed filed on time. So again, what can we take away from that? I don't know if there's any long-term implications, other than the courts seem to be very lenient with the little guys, and it's important to know the proper steps on the objection appeal process. We talked about that a little earlier. But the key ones I would talk about are really you get a 30-day letter, as we call it, where you can negotiate. That's where you should put all your effort in my opinion. If that doesn't work, there's something called a second administrative review that some districts still honor. I don't think Hamilton does. Certain districts will, and others, it's really up to a district or region by region whether they want to do these or not. I've worked with those. Those work pretty good. The next level then is to file your objection. I would say wait your 90 days and then go to Tax Court of Canada. Has anyone, this is an issue I want to talk about later, one of the big issues that practitioners brought up is that if I go to the Tax Court of Canada, I can hum along the first couple parts. You know, there's about 9 procedures, and the 6th one is something called discovery. So I start thinking I'm going really fast, I'm going to be at Tax Court all the time, until I hit this step 6 called discovery, and that can take 2 to 3 years, where nothing happens. You just stop. And one of the big complaints that I've heard from a number of practitioners is what the CRA will do is say, well, oh, you got current claims with the same issue. Well, we can't rule on that. You've already taken it to court. We're going to have to wait till the judge decides till we can give you any shred money for the next couple of years. So it's really not in my client's interest to go to court in many cases and hold up 3 years of claims on an issue that's not absolutely of paramount importance to them. So they tend to just agree on this and agree on that and make concessions. Does anyone have any other avenues that you can do or know any shortcuts to speed that process? Yes?
On the Spectrol case, David, they didn't receive a notice of assessment or reassessment for about 6 years after filing.
This is true. So they filed the objection, but they filed the appeal. They were supposed to, there's a whole bunch more facts, I didn't get into it. They received a notice of assessment, and instead of filing the proper objection, basically, yeah, they filed with the tax court an appeal, and the judge said, well, in substance, it's kind of the same thing. We'll let it go. Now, on getting back to the, say, with a specific as a Spectrol, I'm not sure that it's that relevant to the whole group, other than, what if I want to go to Tax Court of Canada? Do I have to go formal appeal? Does anyone know of any alternatives? Method that I use is, I have the right under the Act to, if I want to limit to $12,000 per taxation year, I can do something called an informal appeal. I don't even have to hire a lawyer. An accountant can do it, I can file it myself. And I generally get my ruling within a year then on an informal appeal. Now my client, if I have $100,000 at risk, I have to limit it to 12 for that year. But the reality is, I'll explain, do you want to lose 90,000 but get a precedent that next year the judge already ruled, we won, you got to give us our money for the next 3 years, or do you want to hold your claims up for 3 years till we go through the superior courts, and you might even lose there and you're out $1 million. And usually it's a no-brainer for the client, right? But yeah, exactly, Pat. So what you're talking about is before we get into the assessment stage, right? Absolutely, I would agree. Negotiate all you can before you get an assessment. 30-day letters, that's the time to provide any information. But if you can't, if they're just not listening, you can't get to an agreement, your rights are then objection, then appeal, right? Not appeal, then objection, as the client mistook there. So I'm not sure that there's a lot to really focus on other than obviously file the objection before the appeal. Don't make this mistake. But at the same time, if you're a little client, tax courts may be lenient with the small and medium guys on SR&ED.